everyone. Did you know you could watch today's meeting live and on your smart device? Head on over to the Hillsborough County Meetings channel on the YouTube app. Click subscribe and turn on the notification bell so you can be automatically notified when Hillsborough County Meetings goes live. You can also browse any of our past meetings by swiping to the left and scrolling down. All that's left to do is just to click on a video. It's that easy!
This is Dave. Dave doesn't know his home's flood zone and was not able to heed flood warnings. Dave and his home are soaked. This is Noah. Noah is an informed citizen. He was warned in advance about potential flooding in his area. Noah took precautions. Noah is dry.
And I saved the animals too.
Good job, Noah. When it comes to flood warnings, be like Noah, not like Dave. For more information, visit hcfl.gov.net. Be safe, be informed, know your flood zone.
Welcome to a meeting of your Hillsborough County Board of County Commissioners. Representing District 1, Harry Cohen. Representing District 2, Ken Hagan. Representing District 3, Gwen Myers. Representing District 4, Michael Owen. Representing District 5, Donna Cameron Cepeda. Representing District 6, Pat Kemp. Representing District 7, Joshua Wostel. The County Administrator is Bonnie Wise. The County Attorney is Christine Beck. Time is set aside at the beginning of each meeting for citizens to speak on any issue. So we have time for everyone. Speakers are asked to limit their comments to 3 minutes. Today's meeting is brought to you with closed captioning by Hillsborough Television.
Good morning and welcome to the January 9th, 2024 regularly scheduled land use meeting of the Hillsborough County Board of County Commissioners. Would everyone please rise for the pledge and invocation given by our chaplain, Commissioner Cameron Cepeda.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Heavenly Father, we come before you today. We thank you for this past year and all that you've done in 2023, and we thank you for your love and mercy and all that you're about to do in 2024. Fire Rescue Chief Dennis Jones, Frank Graves, and Government Relations and Strategic Services John Evenson, and Social Services Paul Johnson, and Library Services Susan Webster. And we pray for everyone in Hillsborough County in their spirit, soul, and bodies. And we thank you and we ask you to bless this meeting today. In your holy name, amen.
Thank you, Commissioner Cameron Cepeda. Mr. Grady, you want to review the changes to the agenda?
Good morning, Commissioners. Brian Grady, Development Services. We do have a few changes to the agenda, and after I go through those changes, I'll then go through the withdrawals, published withdrawals, continuances. Agenda is on page 6, item B1, rezoning standard 23-0782. There is a typo in the applicant's name, and that's being corrected. Second change is on page 11 of the agenda, item C2, vacation petition 24-0001, a revised location map to correct a typo to change book to block in the property description for folio 77690.5018 has been placed in the file. The third change is on page 16 of the agenda, item G1A, PRS 23-0136. The applicant is requesting this item be continued to the February 13, 2024 Board of County Commissioners Land Use meeting at 9 a.m. This next change is on page 17 of the agenda, item G1B, DRI 23-0335. The applicant is requesting this item be continued to the February 13, 2024 Board of County Commissioners Land Use meeting at 9 a.m. And the last change is on page 18 of the agenda, item G3A, rezoning PD 23-0084. A revised report has been added to backup to correct a typo in the listed mathematical maximum entitlements for the post use, ostensibly to remove a reference to acreage and the reference to 215 dwelling units as being the maximums. Those are the changes. I'll now go through published withdrawals and continuances beginning on page 3 of the agenda. A1, rezoning PD 18-0996. Staff is requesting this item be continued to the February 13, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A2, rezoning PD 22-1390. Staff is requesting this item be continued to the February 13, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A3, DRI 23-0195. This applicant has been continued by the applicant as a matter of right to the February 13, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A4, PRS 23-0210. This application is being continued by the applicant as a matter of right to the February 13, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A5, PRS application 23-0508. This application has been withdrawn by the applicant. Item A6, DRI 23-0591. Staff is requesting this item be continued to the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A7, PRS application 23-0767. This application is out of order to be heard and is being continued in the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A8, PRS application 23-0789. This application is out of order to be heard and is being continued in the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A9, PRS 23-0838. This application is out of order to be heard and is being continued to the March 19th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A10, PRS application 23-0877. Staff is requesting this item be continued to the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A11, Special Use LE 23-1103. This application has been continued by the applicant as a matter of right to the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A12, 24-0013. Staff is requesting this item be continued to the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A13, PRS application 24-0027. This application is out of order to be heard and is being continued to the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A14, PRS application 24-0064. Staff is requesting this item be continued to the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A15, PRS application 24-0102. This application is out of order to be heard and is being continued to the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A16, PRS 24-0104. This application is out of order to be heard and is being continued to the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A17, PRS application 24-0112. This application has been continued by the applicant as a matter of right to the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A18, PRS application 24-0129. This application has been continued by the applicant as a matter of right to the March 19th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A19, vacation petition 22-0005. Staff is requesting this item be continued to the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. Item A20, vacation petition 22-0019. Staff is requesting this item be continued to the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. And finally, item A21, vacation petition 23-0011. Staff is requesting this item be continued to the February 13th, 2024 Board of County Commissioners Land Use meeting at 9 a.m. That concludes all changes and continuances.
Can we have a motion to approve the changes?
Move for approval.
Second.
Motion, Commissioner Myers, second Commissioner Cohen. Please record your vote on the changes to the agenda.
Motion carried 7-0.
At this time, can we have a motion to approve the consent agenda?
So moved.
Motion, Commissioner Cohen, second Commissioner Owen. For no comments, please record your vote on the consent agenda.
Motion carried 7-0.
All right, so if anyone here is for a B item, your application's been approved. At this time, if you're planning on testifying today, will you please stand, raise your right hand so the clerk can swear you in?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? All right, thank you. You may be seated.
Okay, now on the vacation public hearing portion of the agenda, Mr. Grady.
The first item is vacate petition 22-0014. Kathleen Pizzone with Real Estate Services will present this item.
Good morning, everyone. Good morning, commissioners. By Revival Ministries International, Inc., to vacate a portion of the improved platted right-of-way known as River International Drive, originally platted as Otto Way Drive, within the plat of Sunway Subdivision, as recorded in Plat Book 82, page 18 of the Public Records of Hillsborough County. The proposed vacate area is located east of Interstate 75, south of Martin Luther King Boulevard, and north of East Broadway Avenue in Tampa. This petition request is made for the purpose of allowing for the petitioners to provide a safe environment for the children and parishioners. The petition was routed to appropriate departments and agencies, and there are no objections to the vacation of the platted right-of-way. However, the Public Utilities Department, Tampa Electric Company, and Charter Communications, Inc., Each have requested the reservation of a utility easement over the proposed area due to facilities maintained in the area. Staff recommends approval of the petition request.
All right, thank you. This is a public hearing. Anyone like to speak to the item? Good morning.
Good morning, Mr. Chairman and Commissioners. Happy New Year. My name is Tu Mai of HT Mai Inc. Office address is 14031 North Del Mabry Highway, Tampa, Florida 33618. I'm here representing the petitioner, Revival Ministries International. Also with me this morning is Chris Ann Hall, Chief Counsel. Petition V22-0014 is a request to vacate a small portion of unimproved platted right-of-way on River International Drive. In 2018, Revival Ministries International filed petition V180026 to vacate a portion of right-of-way of River International Drive from Broadway Avenue to Carway Drive. The petition was approved and recorded in Resolution R19-145. Subsequently, Revival Ministries acquired another parcel having folio number 065528 on March 23, 2022, and filed a petition to vacate the additional portion of right-of-way. They are requesting this small, continuous, and contiguous segment of River International Drive to join the rest of the vacated road and be under the maintenance and responsibility of River International Drive, of Revival Ministries, while ensuring the public is provided with continuous and uninterrupted ingress, egress, and access over the proposed vacated area for pedestrian, bicycle, vehicular, and emergency services uses. Thank you to Jared Delfino and Kathleen Pizzone and their staff, as well as Development Services, for their patience and diligence in working with us on this petition. We received no objections from all the review agencies. In addition, there were no residents who voiced their objections to this petition. However, we do have many here in support of this petition. At this time, could I ask those in support to stand? To conclude, we respectfully request your approval and adoption of this resolution. I believe Chris Ann Hall has a few words. Thank you.
Good morning.
Thank you very much, Mr. Chairman. My name is Chris Ann Hall. I'm Chief Counsel for Revival Ministries International. I just wanted to publicly thank the county and their departments for working with us and having patience to work through all the details. We are on the record fully ready to take responsibility for the maintenance and improvements of this road. We are thankful to Commissioner Donna Cepeda for all of her work in helping us as well. And we want to say thank you to the Board of County Commissioners for your continued support for Hillsborough County. Thank you.
All right, thank you. Anyone else like to speak? Okay, I was wondering why everyone was in the audience here today, and now we know, so welcome. Can we have a motion?
Second.
You got a motion to approve, Commissioner Wolstall, second Commissioner Owen. For no comments, please record your vote. C1.
Commissioner Kemp? Motion carried 7-0.
Thank you. C2.
All right, wonderful.
The next item is agenda item C2 is vacation petition 24-0001. Kathleen Pizzone with Real Estate Services will present this item.
Okay. Item C2 is vacated ID V24-0001. This is a petition from Fernando Trejo and Sandra S. Kennedy to vacate two portions of public platted utility and drainage easements lying within the plats of Tropical Acres South, Unit 5A, Plat Book 47, page 77, and Tropical Acres South, Unit number 5B, Plat Book 51, page 20. The proposed vacate area is generally located east of Balm Riverview Road and north of Big Bend Road in Riverview. The petitioners have submitted this request for future development of a convenience store and a gas station. Reviewing departments, agencies, and utility providers have raised no objection to this request. Staff recommends approval of this petition.
This public hearing, anyone like this item? No, can we have a motion?
Second.
Motion approved, Commissioner Owen, second Commissioner Myers. No comments, please record your vote on C2. All
Motion carried 7-0.
right,
Thank you.
All right, Mr. Grady, on the E items.
Yes, the next item is agenda item E1. It's PRS application 23-0382. This is a request for a minor modification of plan development that's located southeast in the town and country area. If HCV could put up the Elmo, yes, there. This is a parcel that's located in the town and country area, southeast of the corner of Webb Road and Jackson Springs Road. What the request is to modify the type and location of access to Jackson Springs Road for this plan development. Basically, at present, access to Jackson Springs Road is limited emergency access. What they're proposing to do is to provide full vehicular access for an adjacent parcel, zone RSC6, that's to the west of the parcel, that's not within the PD, and then maintain emergency vehicular access to the remainder of the PD. Staff has reviewed this and is recommending approval. We're available for any questions. Thank you.
Is the applicant here? Good morning.
Good morning, Cammie Corbett with the law firm of Hill, Ward and Henderson, representing the applicant this morning. I'm actually here on behalf of my law partner, Clayton Bricklemeyer, who had a conflict in another jurisdiction this morning. Staff explained the request. It's pretty straightforward. The property owned by my client is the property outlined in red. The property to be developed is that property right there directly to the west of the parcel. Those four parcels are all owned by one party. They're going to develop them from a maximum of 12 townhomes. It's a total of 12 acres. There's a lot of wetlands on site. And so they are site constrained about where they can take their access. So they approached our client and asked us if we could accommodate, modify our PD to accommodate their access point, and we were willing to do that. We are maintaining an emergency access for our healthcare uses, which have long been approved, and we don't see any conflict. And we're here to answer any questions. And also, the owner of those properties to be developed that are zoned RSC6 is here if you have any questions as well.
All right, thank you. Anyone here in support of the application? Or anyone in opposition? If not, can we have a motion?
Move approval.
Second.
Motion to approve, Commissioner Cohen, second Commissioner Wostel. No comments, please record your vote on E1.
Motion carried 7-0.
All right, thank you. E2.
Next item is agenda item E2 is PRS application 24-0012. This is a request to rezone a minor modification of existing plan development that's northwest of the corner of Bloomingdale and Providence Road. Commissioners, the request is to remove a reference to maximum square footage floor area ratio for this project. The parcels of the project approved for 100-bed assisted living facility. These type of uses are generally not regulated by FAR square footage. They're regulated by density and also then regulated by buffering, screening, setbacks, and height restrictions. The buffering, screening, building footprint and height is not changing with this, nor is the number of units. There was an incorrect reference to a square footage limitation that was incorporated in the conditions that was not intended to be restricted for this project. So again, the bulk of this request is just to remove that reference to the square footage, and no other changes to the request will be provided, and the staff is recommending approval.
All right, is the applicant here? Good morning, sir.
Good morning, Mr. Chairman. Todd Pressman, 200 2nd Avenue South, number 451, St. Petersburg. There's no changes to this project. It's the same project, same density. I would just call it a housekeeping in terms of how the project is described in the record. Nothing more than that. We've had no opposition on the request through the process. I'll leave it with that. Thank you.
All right, thank you. Any proponent testimony? Anyone in support? Anyone in opposition? Not, can we have a motion?
Move for approval. Second.
Motion, Commissioner Myers, second Commissioner Cohen and Kemp. Please record your vote on E2.
Motion carried 7-0.
All right, E3.
The next item is agenda item E3, PRS application 24-0105. This is a parcel that's located on Cypress Cay Boulevard. It's located on the northwest of Bruce B. Downs Boulevard in the New Tampa, north of the university area. The request is for the parcel indicated in the application to increase the buffer width from a maximum of 5 feet to up to a maximum of 20 feet. The purpose of this request is to provide flexibility in the location of required fencing along the western boundary, because per the Land Development Code, required screening has to be within specified buffer widths, and the applicant desires to relocate the required fence further from that western property boundary. This is actually effectively increasing the buffer, and therefore staff is recommending approval, and we have available if you have any questions. Thank you.
All right, is the applicant here? Good morning.
Good morning. Dallas Evans, Landis Evans and Partners. I do have a brief presentation. I can go to that if you'd like, but this request is limited to increasing a required 5-foot buffer to 20 feet, just the way the condition had been worded in the original PD. Didn't allow staff to allow us to increase that buffer. So with that, I am available if you have any questions.
All right, thank you, sir.
Thank you.
Any proponent testimony? Anyone in support? Anyone in opposition? Not, can we have a motion?
Second.
Motion, Commissioner Owen, second Commissioner Kemp. Please record your vote on E3.
Motion carried 7-0.
Thank you. E4.
Next item is agenda item E4, PRS application 24-0133. This is a minor modification of plan development located on the southeast of the intersection of US 41 and Lacey Road in the Apollo Beach area. The request is three changes associated with them. The first change is to modify required intersection improvements at US 41 Lacey Road in response to revised comments and requirements by FDOT. US 41 is regulated by the Florida Department of Transportation, and the existing conditions reflected what at the time of zoning DOT desired with respect to some intersection designs regarding a dedicated U-turn only lane on the southbound. They now desire that to have dual left turn lanes. Therefore, the conditions are being revised to reflect that requirement. They're also modifying number of out parcels from 4 to 5, and also providing for an additional internal access to the main road from the commercial facility. Staff is recommending approval and are available for any questions.
All right, is the applicant here? Good morning.
Good morning, Elise Batzel, Stearns Weaver Miller. These are really just housekeeping items. As Brian indicated, this is an FDOT required change to one of the conditions. We're also asking to change the number of out parcels from 5 to 6, but no changes in uses, no changes in entitlements. And finally, we are improving the connectivity by splitting one pond into 2 and adding a little road in between. Our team is here to answer any questions that you may have.
All right, thank you. Anyone in support of the application want to speak? Anyone in opposition? Commissioner Owen?
Thank you, Mr. Chairman. Yeah, anytime the Walmart and off Lacey comes up, I have to clarify for my constituents. So, Mr. Grady, this is not changing any entitlements to the property. All we're doing here is getting rid of that U-turn lane, which I don't think I've ever seen that in my district. That's a very unique turn lane that they had, correct?
Correct, and again, they're not changing any of the entitlements as part of this request, but yeah, it's essentially being driven by the request by DOT to change the circulation.
Very good, so I'll move for approval.
Second.
Can I get a motion to approve? Commissioner Owen, second Commissioner Kemp. Commissioner Kemp, recognized.
Yes, I just like to, I kind of watch Lacey Road because I think that the Lacey Road extension is what we need to go east-west across the South County area in between Paseo del Mar and 19th. That it's a really important major grid connection for the future. So I'm pleased to see this.
Commissioner Wolstel?
Yeah, just Mr. Gormley, for the record, this is fully entitled property, and trying to impede their ability to already entitled development would violate their constitutional property rights, correct?
Commissioner, yes, this is an improved entitlements, and the requirement that's in the zoning now is something that DOT will not allow to be constructed. So this change is necessary.
Thank you.
Okay, we have a motion and a second. Please record your vote.
Motion carried 7-0.
Okay, we're on the regular agenda. Mr. Grady, introduce F1.
Next item is agenda item F1, rezoning PD 23-06369. This is a request to rezone this approximately 6 acre parcel from CG with restrictions. The parcel is located on the east side of State Road 579, north of I-4, immediately west of the county landfill. Again, the request is to rezone the parcel from commercial general restrictions to planned development. The plan has a future land use designation of light industrial planned. The applicant is requesting 3 development options for the project. One option, basically, option 1 being about 82,000 square feet of entitlements, proposed manufacturing warehouse type uses. The second option is the same list of uses, just in 160,000 square foot one building, and then a third option, effectively open use of the property. Staff is not supportive of this, not necessarily for the uses that are proposed, because this is in the light industrial plan category. It has more to do with design requirements regarding required buffering and screening and required setbacks based on additional setbacks required for height. The applicant is proposing reduced buffers. They are proposing buffering and screening. They are proposing reduced buffers over the balance of it with some enhanced screening adjacent to some existing homes, and then proposing a reduced setback different than what the code would prescribe based on the maximum building height. Therefore, based on those reasons, staff is not supportive of it. The Planning Commission found it inconsistent, and the hearing officer also did not support it. We're available for any questions. Thank you.
Is the applicant here?
Thank you. Thank you very much. Good morning, Commissioners. Todd Pressman, 200 2nd Avenue South, number 451 in St. Petersburg, Florida. This is a CGR to PD for light industrial uses. We are in the Sefner area. This site is located right at the border on 579 between District 4 and District 2. This is as the property appraiser has the site. Rezoning, a little history. First, currently today it's zoned commercial general with a little restriction. We're seeking to go to light industrial uses. And the type of uses would be manufacturing, recycling, interior, exterior storage, warehousing, distribution. So it would be an employment generator. Now the site is currently approved for commercial general, so could be allowed today for car wash, recyclable materials, convenience store. The only thing that's restricted as of today under current zoning is drive-through restaurant and C-stores. Now, Board of Commissioners, this is very important. A year ago, you unanimously approved the future land use amendment to light industrial. So that was approved by this board. And again, that was January of last year. So what we're doing is following up for the rezoning, which, as you well know, has to be consistent. That's why we're here. And Objective 9, in fact, on page 11 of the big, thick, comprehensive plan, as you know, consistency of zoning in the future land use category is required. Most important is we have had no opposition, zero, through the entire process, nor up to today, as I checked the file yesterday. That's 4 hearings, 5 notices, 5 big yellow signs. That equates to 100 separate notices, and that support or that lack of any opposition is not stated in reports by the DSD, PC, or zoning hearing master. So here's the site to give you orientation. You can see that the landfill is next door, Amazon to the south, and Cascrete. So the predominant feature is the 42-acre Superfund that also accepts hazardous waste, which is directly next door. Here's the Amazon, here's the Cascrete, just to give you a little orientation. So existing land uses clearly show the industrial and the Taylor Road landfill. Future land use category map shows you those intensities as well. And as indicated, there's 3 options of site plan. Option 1, which would be several freestanding buildings, again, for those industrial uses. Option number 2 would be 1 large building with a 49-foot building setback. And option number 3, no structures, again, the proposed buffer at 20 feet. So we're asking for a number of variations and waivers, which basically boil down to a 20-foot buffer and B-type screening on the north, south, and east. Now, the reason directly for that is if we were to apply the setbacks required, as you can see here, it would move more than half of the property because of these setbacks, which is one reason why. Again, we're next door to the landfill as well. That's one of our neighbors. But the crux of the direction here is that the Development Services, Planning Commission, and the Zoning Hearing Master all agree and recognize the intense uses. What they note is the intensity is consistent, and that's a common thread through all the staff comments, but they all have concerns of compatibility to a resident to the north and a few residents on the south. That's the crux of the staff reports. Again, they all recognize compatibility, that the intensity is okay, but the impacts to the neighbors to the north and south. Now, critically, Commissioner, and this is an important finding, in December of 1995, this Board of County Commissioners established a land use policy for development along 579, specifically recognizing the Taylor Road landfill. And that resolution by the Board of County Commissioners notes, due to the unique circumstances of the county landfill and existing non-residential development pattern in the area. That's an important finding by this board because of the impacts of, obviously, a 42-acre Superfund landfill. And that was followed up by the Thanona-Sassa Community Plan, also indicating, recognizing uses along 579. But here's the most important point. There's only about 5 or 6 homes that are affected. There's one to the north and several mobile homes to the south. They're all owned by one family. The owner to the north has no opposition. The owner to the south has no opposition. The owner to the east is the county landfill. So these are emails that are in the record. And in this case, I spoke personally. I met with one owner to the north, and I spoke with the owner to the south. Again, they have no opposition to the zoning whatsoever, which directly addresses the specific concern of the Development Services, Planning Commission, and Zoning Hearing Master. Again, these are 2 folks that I personally spoke with in this circumstance. Again, that follows up on the specific land use resolution this Board of County Commissioners found. Why is that? Because when you look at living next to a landfill, there's a propensity for respiratory diseases, garbage and litter, contamination of the air, and obvious difficulty of sales of a property. Now, when you look at the overall general vicinity to the south, you can see Amazon there. It's a very intensive area, again, recognizes that landfill. But here's another really important finding for you. The recent Amazon approval, which is to the south in terms of buffers and screening, that was approved with a 20-foot B-type buffer. The same screening and buffer that we're proposing. Topographically, geographically, that is on the south end of what we're proposing. On the north end, same 20-foot buffer approved for Amazon, and when you can see it, Amazon was approved for manufacturing. They have a lot of outdoor activity. They have trucks lining up 24/7, idling, loading. We're proposing that same buffer that staff has concern with on the north side of our property. The other thing that we've done is we added a 100-foot exterior activity exclusion zone by the residential home to the north and to the several mobile homes to the south. We've added a further restriction for exterior activity within 100 feet of those homes, even though both property owners have signed off for no opposition. And this is just a little bit of, not the scale, but showing the additional screening. And transportation is no objection, though they will approve the changes as proposed. So in summary, the rezoning is required for consistency. And most importantly, this is an LIP, light industrial plan development. A plan development is required. It cannot be moved forward without a PD. So you have surety and guarantee that whatever is done here must be a plan development. It already has commercial zoning and intensive uses that I walked you through. The uses, zoning, future land use categories are very intensive in the immediate area. I made you aware about the specific BOC directive in regarding this particular area. We've had 0 opposition, providing additional screening. We're written 100% support from adjacent to the north and south property owners that the staff had concern with. The same buffer screening on the abutting property to the south is the same. And again, transportation is in support. I will say again, an emphasis that we see the site as an employment generator in this particular area, and we think that's a very good positive. So with that, we appreciate your attention and consideration. Thank you.
All right, thank you. Anyone in support of the application? Anyone in opposition? Planning Commission?
Thank you. For the record, Melissa Leinhard, Planning Commission staff. The subject property is located in the light industrial planned future land use category. It is in the rural area, and it's also located within the limits of the Thenodisassa Community Plan. The subject site is surrounded by residential 4 to the north, west, and south, and the public, quasi-public future land use category is located to the east, and then there's additional light industrial plan future land use category located to the south. The overall intensity of the 3 development options is consistent with what can be considered in the light industrial plan future land use category. However, these options present significant compatibility concerns with regard to the established residential uses to the north and south. The proposed development options are more intense in nature and do not consider the uses located within the residential 4 future land use category immediately abutting the site. The proposal is therefore inconsistent with Objective 8 and Policy 8.1 of the future land use element. Similarly, the proposal conflicts with the intent of Objective 16 and its accompanying policies related to neighborhood protection. The proposed buffering techniques do not provide an adequate transition of intensity between the subject site and the adjacent residential land uses. The development options do not complement the surrounding residential area. While the site meets the criteria of Policy 16.5 of the future land use element, proposing the building setback from the roadway negates the intent, which is to place higher intensity non-residential uses on major roadways rather than directly next to residential neighborhoods. Overall, the requested PD variations to buffering and screening requirements do not allow for a gradual transition of intensity between land uses and are therefore inconsistent with this policy direction. The site is within the limits of the Thenodisassa Community Plan, as I mentioned, and the proposed plan development meets the intent of the plan as the adopted language does allow for commercial uses along State Road 579, south of Pruitt Road, all the way to Interstate 4. However, it also strives to protect the area's rural character, and the proposed site plan is not sensitive to the low to medium density residential uses that are located to the north and south of the site. The light industrial uses as shown on the site plans do not protect the existing rural neighborhood character. To be clear, Planning Commission staff is not opposed to a light industrial use in a light industrial planned future land use category. It is the proposed reduction to the buffering and screening requirements that are inconsistent with the direction of the comprehensive plan as it relates to compatibility and the community plan language. And based upon those considerations, Planning Commission staff finds the proposed rezoning inconsistent with the unincorporated Hillsborough County Comprehensive Plan. Thank you.
Hearing Master.
The zoning hearing master considered the applicant's request to rezone the subject property to plan development to allow up to 160,000 square feet of manufacturing, recycling, warehouse uses with outside storage, support office, and ancillary uses. The applicant is proposing 3 development options. For development option 1, the applicant is requesting a waiver of the additional 2-to-1 building setback for structure height over 20 feet to allow a 20-foot building setback along the subject property's north, south, and east boundaries where the land development code would otherwise require a 60-foot setback, in addition to the required 30-foot wide buffer for the proposed 50-foot structure height. For option 2, the applicant is requesting a waiver of the additional 2-to-1 building setback for structure height over 20 feet to allow a 49-foot building setback along the property's north and south boundaries, where the code would otherwise require a 60-foot setback, in addition to the required 30-foot wide buffer for the proposed structure height. The applicant is requesting a waiver of the additional 2-to-1 building setback for structure height over 20 feet to allow a 79-foot building setback along the subject property's east boundary, where the code would otherwise require an additional 60-foot setback, in addition to the required 30-foot wide buffer for this proposed structure height. The applicant has proposed a condition to prevent open storage uses within a 100-foot radius from the residential structures on adjacent properties to the north and south. The zoning hearing master concurred with the compatibility concerns contained in the recommendations of Planning Commission staff and Development Services and recommended denial of the plan development rezoning.
Commissioner Owen.
Thank you, Mr. Chairman. And Mr. Pressman, I'll have you up front too as well. I know I'm pretty, if you can come up front. I know I'm pretty hard on you, but you bring me the dicey ones in my district, so. Mr. Gormley, so with this particular property, really what we're dealing with, if it wasn't for the setback issues, development services would be in approval. So we're really, let's narrow this down. We're talking about the setbacks, correct?
Yes, correct.
And Mr. Pressman, there's three options that you provided. One shows an 82,000 square foot structure, one 160,000 square foot structure. One of them has like 7 structures, one is just 1 structure, and then one is just, looks like it's just land, correct? So I guess, is there anything we can do on these setbacks? What is I know you kind of touched on it briefly, but what would those setbacks, and complying with the setbacks, do to what your client is trying to do, I guess, is what I'm asking.
If we go back to the PowerPoint for a minute, just a minute, please. If we were to apply the setbacks by code, it would remove 50% of the property.
50%.
But I would say this is a very unique site, being located directly next to the landfill.
Yeah.
And again, brought forward the written no opposition to the owners on both sides. If we didn't have that, I think we clearly would have brought this forward differently. But with their unwavering no opposition, we felt that it was appropriate.
Well, I think that's important, what you said, 50% of the property, if you comply with the setbacks, would not be usable. Mr. Gormley, and we're correct saying that we have the same owners to the north and south of this property, correct?
Correct. Common ownership on both borders.
To clarify, it's the same family, but
Okay.
2 different owners.
Okay, got you. And then there's a large warehouse to the south.
Yes, sir.
To the west of the street, and the east is the landfill, correct?
Yes, sir.
Doesn't look like we're disrupting residential in this particular situation.
Certainly that's, yes, sir.
With respect, Commissioner, I'd also note the Cascrete manufacturing processing, which is virtually across the street as well.
Yeah, this one, Commissioners, is kind of similar to when we were dealing with a soccer field, if you all remember that a while ago. It's different, but it's the same in some ways. Would you agree with that, Mr. Gormley?
It's a similar, sorry, our comments are similar, and it was a precautionary compatibility recommendation. So there's similarity there, yes. It's certainly a reasonable minds could differ call.
Yeah. Yeah. So yeah, I just don't really know what else could go on this property, Commissioners. And to me, this kind of development here in this particular situation, so close to a landfill, this just makes sense to me. So I am going to move for approval on it.
Second.
Okay, we got a motion to approve Commissioner Owen, second Commissioner Cameron Cepeda. Commissioner Wostel.
Thank you, Mr. Chair. Yeah, I think the item's fine. Mr. Gormley, I'm trying to figure out the year gap. Is that a symptom of like our internal processes that caused it to take so long, or because if it is, I just want to have a future conversation about that.
The year gap?
Because we approved this and then it's taken a year to get to the rezoning. Is that the natural timeline?
That is at the sole discretion of the applicant when they choose to come in with their rezoning application.
Okay, so we don't have delays in our process that would have, okay.
There are 2 separate processes, 2 separate applications.
Perfect. All right, thank you.
Okay, we got a motion, a second. Please record your vote.
Motion carried 7-0.
All right, F2.
Commissioners, the next agenda item is agenda item F2, is rezoning PD 23-0517. This is a project that's located on the south side of 122nd Avenue and Old Morris Bridge Road, but it's also located northeast of the intersection of Fowler Avenue and I-75, but again, its access is via Old Morris Bridge Road and 122nd Avenue. The request is to rezone the parcel to allow for a number of option uses, including contractor's office with or without open storage, warehousing, warehouse distribution, mini warehouse, commercial vehicle sales and service, and trucking, storage, and terminal. Based on surrounding land uses and based on the position of this property along and adjacent to I-75 and Fowler in the restricted uses. And also, I would note that there are requirements within the conditions of approval to make improvements to Old Morris Bridge Road and 122nd Avenue, and also including making improvements to a bridge that crosses creek nearby. Based on those provisions, staff did find this consistent and approvable. The Planning Commission did find it inconsistent. The project is subject to locational criteria and does not meet location criteria, and therefore Planning Commission did not support a waiver. The hearing officer did recommend approval, and staff's available for any questions. Thank you.
Is the applicant here? Good morning.
Tina Grimes with the law firm of Bradley, Arendt, Bolton Cummings, and I'm here this morning representing the applicant. So the subject property, as Brian has told you, is at the northeast corner of the intersection of I-75 and Fowler. It's a fairly large site, about a little bit more than 15.5 acres. The comp plan category is SMU 6, which, as you know, allows a variety of uses, including even light industrial uses. The current zoning is AR. The current use is the site is dormant. Previous use, and this is important, similar to the last application, this use, the previous use on this property was an actual landfill on this property operated by Hillsborough County. The proposed uses are limited commercial intensive uses. And as I go through this presentation this morning, it's our intent to provide you with 3 primary reasons that this project is appropriate and the rezoning should be approved. The first reason is that the previous use as a landfill substantially limits the viable uses of this property. It's that simple. It was an actual landfill. The second reason is the SMU 6 comp plan category and the comp plan policies and objectives that you have dealing with development in the I-75 corridor make this an ideal site for CI type uses. And the third reason that we think supports this application is that the extensive buffering and screening we'll show you ensures that it's going to be compatible with the surrounding uses. And we think that's why the staff, in fact, supported the application and why the zoning hearing master, in spite of the Planning Commission's recommendation of inconsistency, it's why the zoning hearing master recommended approval. So here's some current images of the site, and what this is intended to show you is the extensive landscaping of the trees and the dense vegetation along the edges of the site, and we intend to retain that. Here is on 122nd Avenue on the north of the property where our access is, and you'll see the property to the left is got a berm, about an 8 to 10 foot berm with extensive vegetation and landscaping, again, that we intend to retain. Again, this is 122nd Avenue. It's a better view of the berm that you can see that runs along the entire frontage on 122nd. So this will all remain intact. So what are the surrounding properties? You have I-75 on the west, and then on the south you have Fowler Avenue. To the east you have a Swift Mud property, which is a conservation park, and then further to the east you can see the bypass canal. But on the northeast, across 122nd Avenue, what you have is 3 single-family conventional structures, and then you have a mobile home with open storage. You also have adjacent to the site a property that's under development right now. We were told it was for self-storage, but according to the permit that's been filed, it apparently is going to be developed for office and residential. Here's the surrounding area along Old Morris Bridge Road, and what this is intended to show is that this area is not an established neighborhood, isn't necessarily in good condition right now. You have all these abandoned vehicles and trailers and trucks that are lined up along the east side of the roadway. Here you have the property that's immediately to the north of the site. You can see that it's got a mobile home, but it's also used extensively for open storage. You have old motor homes, old tractors, boats, trailers. You even have a huge pile of telephone poles that are stored there. This is that property I mentioned that's currently under construction and is being developed either for self-storage or for office. We're not clear on that point. So the history of the site as a former landfill, it was operated by Hillsborough County as a landfill from 62 to 69. And first it was developed as a borrow pit on the western side of the property. There was a 30 to 35 foot deep borrow pit that was ultimately filled with municipal solid waste. And then on the eastern side of the property, there were trenches that were dug to accommodate the landfill. And the landfill accepted residential, commercial, industrial, construction, and demolition debris, pesticides, and other, quote, questionable materials. So it's a difficult site to deal with. These historical images are important for a couple reasons. First, they show that in 1957, when property was first being developed as a borrow pit, there was no residential in the area. You can see on the north side of 122nd, that also was developed as a borrow pit. When you move to the 65 aerial, you can see on the north side of 122nd, where there was a former borrow pit, there are now those residential structures. And then, of course, you can see that the site itself was developed or borrow pit and a landfill on the west side, nothing on the east side. Then back by 69, you can see that even the east side of the property was developed. We had an environmental engineer evaluate the viable uses on the site. They said it was an excellent candidate for heavy commercial and light industrial because of the way that these types of uses are constructed and the fact that there would be limited exposure to occupants. We have a letter from DEP, state DEP, which essentially says the same thing. So we know residential is not appropriate. We know agricultural is not appropriate because of the soil conditions and the contamination. And commercial uses that have members of the public come to the site and stay there for longer periods of time also is not appropriate. So we feel like we're really threading the needle here with the potential uses, which we think are these limited CI uses. And here are the uses that we are proposing. It's a contractor's office or open storage and sales, sales and rental of new or used commercial vehicles, mini warehouse, or a trucking terminal. When you look at the CI development standards, we meet all and we exceed some of the development standards. Which ones do we exceed? The most important one, and that's the buffering and the setbacks. We exceed those by a large, almost quadruple the amount that's required. Now, I'll show you in just 1 minute what I mean by that. But we meet all the other development standards. We also doing substantial improvements, as Brian mentioned, to Old Morris Bridge Road and to 122nd Avenue, both of which are substandard roadways right now. So here is the buffering that I wanted to show you. Here's the site. You can see 122nd Avenue on the north. You have a 30-foot landscape buffer on the north end. That landscape buffer is going to be what you saw in those pictures. We're going to retain all of those existing mature trees and all that existing dense vegetation. And then behind that, on our site, we'll put a 6-foot fence. Then beyond that, we're going to have a 70-foot stormwater area. And then beyond that, we're going to have another 25 feet additional buffering. So for a total of 125 feet distance, we will be buffering those residences to the north. You can see on the east side, there's also an extensive buffer, 165 feet. And on the south side, you have 85-foot buffer. So as I mentioned earlier, it's only the Planning Commission that found this project inconsistent. We don't agree with their position. We think that they misapplied these two objectives and policies to this application because they interpreted that area to the north as an established neighborhood. We don't believe that it meets the definition of an established neighborhood. And the reason that we don't believe it does is because it is, these residences were constructed in a non-residential industrial area at the time. They aren't integrated into a larger community. They have not been, it's not 80% developed as the comp plan definition of a neighborhood requires. And then as time has gone on, one of the residences to the north on the mobile home, it's deteriorated over time. There's also no registered neighborhood association, and we think for those reasons it does not constitute a neighborhood to which the comp plan policies should apply. Also, as I want to go back just and also make the point that while those residences to the north exist, we are also attempting to buffer those. As I showed you just earlier, we have extensive buffering with the 125-foot setback, retaining the existing development, the 6-foot fence, the stormwater pond. All of that provides the buffering you need. I think also the one item that the Planning Commission, we believe, overlooked is the I-75 corridor development and the comp plan policies that you have dealing with that. They didn't consider those into their decision and finding it inconsistent, and we think those are important. The comp plan policy states that you should have a clustering of high-intensity uses along the interstate. They also say that residential opportunities should be limited in these comp plan categories so that you have these employment centers.
Thank
And
you.
then last, I'll just finish with, we do have our neighbors to the north who we've met with a couple times, and
Thank you.
they'll address their concerns.
All right, anyone in support of the application? Anyone in opposition? Please come forward. Good morning.
Good morning. My name is Jerry here, and I reside at 9016 122nd Avenue, and I represent the 4 property owners and resident families comprising the 13.58 acres of a unique agricultural neighborhood. We would like to thank the zoning master and Mr. Bryce Farringer for acknowledging that our residences do meet the criteria of an established neighborhood. In a 65-year span, only 9 families have lived within our neighborhood. The average length of residency is over 28 years. That speaks volumes as to the quality of life here with the potential natural wonders and peacefulness. We all purchased property in this area because of its wide open, off the beaten path atmosphere with zoning restrictions that promise to keep it that way. We're removed, yet close to so much. Ms. Grimes stated that per aerial photographs of our neighborhood circa 1957, there were no homes present prior to the county landfill that operated within the boundaries of the property in question. And that may have been true in 1957, but according to county records, the home at 9022nd on 22nd Avenue was built in 1959. The home at 9020 122nd Avenue was built in 61, both before the county landfill began operation in 62. Ms. Grimes also stated that a portion of our combined 13 acres has been used as a landfill. That would be more specifically the 9016 and 9020 122nd Avenue addresses. These 2 areas were used by the county as a relocation site for dirt that was being removed from the Tampa Bypass Canal, which was being constructed. However, that dirt did not then, nor does it now, contain the toxins that were dumped in the county landfill during its operating years, the landfill that was located within the boundaries of the property in question. Toxins so lethal that core samples from the county landfill forced construction plans for I-75 to be altered to go around it, toxins that were dumped after the construction of homes within our neighborhood. In 1997, the county acknowledged responsibility and provided deeper sealed wells at no charge to our neighborhood residents with quarterly and then semi-annual inspections that continue to this day. Mention has been made of this area being in the I-75 development corridor. I'd like to comment that all the homes within the neighborhood predate 1975, predate the construction of I-75. Ms. Grimes also mentioned the property at 11930 Old Morris Bridge Road as being under development. Work has been ongoing intermittently since 2014 when ground was broken. The contractor office trailer has been on site since 2017. At some point, zoning was changed from AR to CN without any visible public notification. To our knowledge, LaCauley and Associates has not had permitting for any work. Mr. Lampkin had stated that he had found none to date. These are our specific concerns regarding this proposal. Number 1, high volume of traffic would be generated. The applicant is proposing road improvements to both Old Morris Bridge Road and 122nd Avenue to handle excess traffic. A 12-foot travel lane, 24-foot lanes of traffic, and 8-foot stabilized shoulders. Their project drawing shows a complex of multiple businesses, and their proposal mentions a trucking hub or distribution center. Our current traffic is approximately 25 to 35 vehicles in a 24-hour period, easily complying with agricultural's minimal trip generation. What the developer applicant is proposing could result in an excess of 900 vehicles a day, 24 hours a day. That's easily 20 or more times the current traffic load. And during what hours? 24/7? While Ms. Grimes is correct that living next to I-75 does come with its share of impactful sounds as well as fumes from cars and trucks, that is still a distance of nearly over 350 feet. However, having a possible excess of 900 additional vehicles or semis per day, now within a few feet of our homes, will create much more of an environmental noise and air quality issue, and that is unacceptable. Then there are an existing 90 new homes at the north and old end of Old Morris Bridge Road. The traffic flow in and out of that area is badly jammed during peak rush hours. There's a plan to build several hundred more homes between 122nd Avenue and those 90 homes. Just how will that traffic flow be handled, plus the addition of a possible excess of 900 vehicles per day from this project? We're not opposed to progress, but progress can be a good thing. But at what cost and by whose measurement? Number 2, water quality. From an environmental standpoint, even though the new construction will be drawing water from Temple Terrace draws its water from the aquifer upstream of our wells. Not to mention they require installation of fire hydrants. Our previous wells were damaged due to subterranean runoff from the north to the south, while the aquifer flows from the south to the north, while the aquifer flows from the north to the south, per the well contractor. We are concerned about the adverse effect that extra pumping will have on the aquifer that our wells draw from. Number 3, the value of our properties. We have no idea what that impact is going to be. Number 4, excess lighting from buildings, parking lots, and streets. While Ms. Grimes stated that the county has a code requirement that strictly limits on-site lighting on-site and makes sure the lighting doesn't overflow onto adjacent properties, the applicant is proposing landscape barriers and berms and retention ponds and a large setback. The plan also suggests the height of structures will be consistent with a 50-foot height limitation. That's 5 stories tall. And if this project includes annexation to Temple Terrace, sidewalks and street lighting above them will be mandatory. Bright lights and overhead street lights within a few feet of our homes, even with reflectors, will not go far to shade our homes, especially on a foggy night. With all the water features around us, fog is a normal occurrence. The glowing halo of interstate lighting is a testament to that, and now they want to add more. Number 5, the adverse effect it will have on our quiet and peaceful neighborhood. The wildlife within our neighborhood is breathtaking. We have deer, wild turkey, coyotes, bobcats, an occasional Florida panther, graceful hawks, and beautiful water birds, and yes, herds of destructive feral hogs. When the I-75 expansion was done a few years ago, thousands of acres of forest were destroyed, as were the homes to this precious wildlife. When the 90 homes were built a few years ago, and at the far end of Old Morris Bridge, even more habitat was destroyed, resulting in even more wildlife losing their homes. Now with this proposed construction, more wildlife habitat will be destroyed. That's just sad. Number 6, the uncertainty. The lack of guarantee that our lives as they are today will only be minimally impacted. Unless we can have that guarantee, then we have to agree with Mr. Farringer that this zoning change does not fit within the county guidelines, that the intensity of the proposed use is out of character with the existing residential development, that the nature of the request directly conflicts with SMU 6, and that it will negatively impact wildlife habitat and other non-intensive commercial or offices would be more compatible with surrounding residential uses due to the intensity of their project. We applaud Mr. Farringer's statement that the waiver is not supported by the Planning Commission staff and that his recommendation is that the BOCC not grant the waiver and uphold our agricultural status. The county would literally be forcing us out of our homes by allowing rezoning. Therefore, we beg the BOCC to not grant the waiver, but to rather uphold the current agricultural status. This is not the matter of a neighborhood moving next to a truck stop and then complaining about the hours of operation, noise, traffic, smells, etc. It's a matter of a truck stop invading a neighborhood and forcing disruption into our peaceful lives. Thank you for your time.
Thank you. Anyone else here in opposition? Okay, applicant has a 5-minute rebuttal.
Gina Grimes, for the record, with all due respect to Ms. Herr, a lot of the testimony she provided this morning was not presented to the zoning hearing master. There was a lot more additional testimony that was presented this morning. At the zoning hearing master, she presented basically 3 objections. The first was the traffic. As you'll see in the site access analysis that we presented, we are making roadway improvements to Old Morris Bridge Road and to 122nd. We have FDOT is requiring us to do an evaluation of the intersection of Morris Bridge and 127th to make sure that the planned improvements there will also be adequate to accommodate the project traffic. And then the analysis also shows that the level of service on the adjacent roadways will be at an acceptable level of service, even with all of our project traffic. The second issue on the water quality was something she brought up at the zoning hearing master. We had testimony from our engineer who's here this morning, if you'd like to ask him questions, but basically what it came down to is that the site as it exists right now, former landfill site, does not have a stormwater management system on it at all. So all of the runoff from that site goes from the site onto the road and over to the residences to the north. With this project development, we will construct a stormwater management system that will contain all of that runoff that now runs onto their property, and it will be dispensed to other areas. None of the runoff will go now to 122nd, so actually it'll be an improvement, if anything, to their water quality. The third issue that they raised at the zoning hearing master was with respect to the noise. And we did make the point that the I-75 is just, 100 feet away from their homes. So the noise that they experience already from I-75, we don't believe is going to be exacerbated. And why is that? Because of the mitigation that we're providing. The compatibility with the extensive setbacks, we think, will buffer a lot of the noise that they might otherwise hear. Really what it comes down to is a question. She said, Ms. Herr said that the uses are out of character with the neighborhood. The real question is the neighborhood out of character with the area as it was originally established as a borrow pit and a landfill? We think that that is in fact what the case is. These are three residences that chose to locate across the street from a borrow pit at the time and then a landfill. And that landfill, while only operated by the county from 62 to 69, it accepted waste over time. So it's not as if nothing's occurred on site since 69. It has been accepting materials. Materials have been deposited there over time. So we think this is an established commercial intensive / industrial area. We think, if anything, the residences are out of character with that, and we think for the reasons that we identified at the beginning of the presentation, the three principal reasons this should be approved is because the previous use as a landfill substantially limits viable uses of the property. There's very little that can be done with this property other than what we're proposing. The SMU 6 comp plan category and the I-75 corridor comp plan policies support these types of uses on this site. And then lastly, we go back to the compatibility measures. We've made extensive efforts to make sure that this project will be compatible with these three residences that are on the north. And if you have any other questions, we have our team here for those questions.
All right.
Thank you.
Thank you. Planning Commission.
Thank you. For the record, Melissa Leinhard, Planning Commission staff. The subject property is located within the suburban mixed-use 6 future land use category. It is in the urban service area, and it is not located within the limits of a community plan. The SMU 6 future land use category extends north of the subject property, and to the south are the public, quasi-public, and community mixed-use 12 future land use categories. To the east and west is the natural preservation category, and further to the west are community mixed-use 12 and residential 20 categories. Objective 1 and policy 1.4 of the future land use element encourage compatible development within the urban service area. The proposed commercial intensive uses are open storage of vehicles, a mini warehouse use, and contractors' offices. These uses are not consistent with the existing character and development of the area. While the applicant is providing enhanced buffering, screening, and setbacks, the proposal does not meet the intent of the neighborhood protection policies as outlined under Objective 16 in the future land use element. The residential dwellings north of the site are existing developed homes and meet the definition of an established neighborhood. The request would facilitate encroachment into the residential area adjacent to the subject property and immediately to the north, which requires gradual transitions of intensities between land uses to be provided. Though the applicant has submitted proposed mitigation measures, the intensity of the proposed use is out of scale with the existing development pattern in the area. Similarly, the nature of the request directly conflicts with the community design component's policy direction, ensuring that new developments are compatible with their surroundings. The site also does not meet established commercial locational criteria for non-residential uses, and the applicant has submitted a waiver request pursuant to Future Land Use Element Policy 22.8. While the site is adjacent to Interstate 75 and is a former landfill, other non-intensive commercial, residential support uses, or office uses could still be considered on the site and would be more compatible with the surrounding residential uses. Due to the intensity of the proposed uses encroaching into the residential area to the north, Planning Commission staff does not support the waiver and respectfully recommends that the Board of County Commissioners not grant the waiver. A portion of the southeast quadrant of the site is located within the significant wildlife habitat, and there should not be any impact to this area during the site plan review process, as those impacts would not be consistent with policy direction outlined in the environmental and sustainability section of the comprehensive plan. Based on those considerations, Planning Commission staff has found this proposed rezoning inconsistent with the unincorporated Hillsborough County Comprehensive Plan. Thank you.
Hearing Master.
The zoning hearing master considered the applicant's request for rezoning of the subject property to plan development to allow development of limited commercial intensive uses, including contractor's office with or without open storage and sales, rental and service of new and used commercial vehicles, buses and trucks, a mini warehouse, a warehouse with or without a distribution center, as well as trucking and truck terminal use. The applicant is proposing a 30-foot wide buffer and type B screening, as well as a 125-foot front building setback along the property's north boundary abutting 122nd Avenue. The applicant is proposing an 85-foot building setback on the subject property's south and west boundaries abutting Fowler Avenue and the I-75 on-ramp, and a 165-foot setback on the property's east boundary abutting the Southwest Florida Water Management District conservation lands. The applicant is proposing a 6-foot tall opaque fence on the property's north boundary at the 30-foot buffer line and along the east, west, and south boundaries. The zoning hearing master also noted that the applicant is proposing to retain existing vegetation along the property's north boundary in lieu of the type B required screening. The zoning hearing master referenced aerial photographs on the property appraiser's website and street views on Google Maps that concur with photographs submitted by the applicant showing substantial heavy vegetation and a berm along the property's north boundary abutting 122nd Avenue. With the consideration of the design and layout factors, the zoning hearing master did find the request to be approvable and recommended approval of the planned development rezoning subject to the conditions set out by the applicant and agreed to in the Development Services Department staff report.
Commissioner Wostel?
Can you clear up the statement about the CN and the lack of permits, the work trailer that's been on Morris Bridge Road forever? Is there any, and while they're working on that, do we know when the landfill was sold to the current owner? And I'll get to why that's important to me.
I can find that information. I don't believe that we have that at hand, but it should be accessible.
I guess I've never heard an applicant say out loud, at least, that the argument is that the residents don't belong there because of where they bought. I found that confusing, but I guess the point that I'm going to lean into on that is almost certainly the homes were pointed out to have existed there prior to the landfill existing and being in operation. Is that correct?
Well, Commissioner, I'm going to confirm the dates here. We have information that there's a historic landfill. Don't believe we have immediate information on the timing of the homes being constructed other than the testimony here. of the homes being constructed relative to the cessation of use of the landfill.
And then almost certainly the current property owner owns the property now after it was a landfill and after the homes were there. So I guess my point to the board members is, well, the argument is being made that the homeowners allegedly don't belong there because of the character of the area and them deciding to build near a landfill. Well, the same argument could be made for whomever owns the property now voluntarily bought it as not SMU 6 and knowing that there were current residents there. And I guess that was I was surprised that it was said, but the danger in making that argument is that the same counter argument can be made against the current owner since they weren't the owners of the landfill, I'm presuming. I guess for those reasons, I'm not going to support it. It sounds like what I'm saying is correct if you don't have the information, but we can agree that the county owned the landfill and then has now surplused it at some point in the past after it was a landfill to somebody else.
Yes, and I'm about to get the transfer information.
And while we're working on that, what could this property be? Since the Planning Commission denied it, what do you guys have like a vision of what could get to a yes on this property, or is that?
That's a great question, Melissa Leinhardt for the record. In our report and my testimony, we listed some potential uses like a residential support use. So that could be something like assisted living facility, daycare, church, school, something like that. We also talked about office uses, or maybe even something like a less intensive commercial could potentially be considered. It doesn't meet commercial locational criteria, but it was the list of uses that were proposed just directly adjacent to those established homes that presented significant compatibility concerns for us.
Okay, that's very helpful. Thank you.
Adam, you find anything?
Commissioner, for the first parcel, the information went back to 1972 and did not show county ownership. I'm looking at the second parcel as we speak.
Okay. I hope that I've made my point, though. It's dangerous to suggest somebody shouldn't live there. Property changes hands all the time, and clearly the most current owner of the landfill bought it after these homes existing, so they knew it was there. So I don't believe that that's a fair argument to make against current residents in the county. So I won't be supporting it. Thank you.
Commissioner Owen.
Thank you, Mr. Chairman. And Commissioner, I see your points on that. I'm going to kind of move those to the side, who has a right to be there or not, and just kind of focus a little more on the objections, because the objections are to the property, Mr. Gormley, to the north, correct? Am I right on that? I want to make sure. Opposition to the north, I think that's right. Yeah, so as to traffic, I mean, I kind of wish that all applicants would agree to improve roads like this whenever they're bringing in a development, because do we know, Mr. Gormley, the exact improvements that they're going to be making? Because I see they're going to improve the bridge and the road, and these seem like they're pretty significant changes. Could you touch on that? Because obviously traffic's one of the biggest things I preach on in moving vehicles, but if you're improving a property like this, but yet you're improving the roads in a significant way, that definitely, weighs my decision.
Yes, Commissioner, there is, I would agree, there's significant road improvements that are required of the applicant. They will be required to bring the Old Morris Bridge Road up to 12-foot lanes with 8 feet stabilized shoulders up to the point of access on 127th Street. So that will provide, we believe, is a very adequate and sufficient roadway improvement to accommodate the impacts of this project. And those 12-foot lanes and 8-foot stabilized shoulders will also be constructed on 122nd Street where it turns east-west. So we believe that those are adequate improvements to accommodate the impact of the project and would not cause disruption to the area due to the current condition of the road is pretty substandard.
And we've got some really close proximity here to the interchange. So I'm looking at the 6, I guess, issues that were brought up. Traffic, I think, is addressed. As far as water quality, they're going to go through rigorous. If you could just comment on that.
Yes, sir. Their stormwater management system will be subject to permitting by both the county and SwiftMud, and that will address both the water quantity and the water quality as well, requiring that the water be adequately treated before it leaves the site. Will be part of the permitting process if this is approved.
And lighting as well. They're gonna there's standards that they're gonna have to meet.
Yes, they'll have to meet the county's exterior lighting regulations, which call for limitations on foot candles at the property boundary, and lighting to accommodate those limitations.
And then environmentals and study for wildlife. I'm just trying to get the concept of the wildlife off the interchange there. Could you talk about the impacts?
So we've identified this has mapped significant wildlife habitat. There's a condition in the rezoning that requires that that habitat be maintained if it's field verified as being present. Our regulations require conservation or preservation of up to 50% of the site if it's viable, significant wildlife habitat, and that will be something that is addressed at the permitting stage. Again, if this is approved, and if changes are necessary to the site plan to accommodate that wildlife habitat, that's conditioned as well.
Okay, great. That's all I had. I'll sit back and listen. Thank you.
Commissioner Kemp.
Thank you. I think it's difficult when you hear both sides of this, and I think the resident made a extremely compelling case. I'll just say that, and I think the analysis. I had an impression that somehow Commissioner Wistel, I thought your questions were and concerns were good with regards to this. I also was like, this is a challenging piece of property to develop. So what can go there? And does it have to be this? And there's the questions about, I guess it was a county landfill and then probably sold at whoever had it at any point. I'm sure it's relatively inexpensive property to buy, I'm guessing. And this looks like maxing out in terms of scale and intensity, and that's exactly what the Planning Commission kind of talked about, the intensity and scale as being hugely impactful. And I think hearing from the community in that area, I'm inclined to deny due to the intensity and scale. I know it sounds like a very challenging piece of property to develop, but that it could come back with something that may not be quite as impactful and, as I say, as quite at that scale and intensity.
Okay, I'll just say I'm like sounds like other board members. I'm kind of torn on this because I understand the concerns from this here. At the same time, it does appear that they're improving the transportation, roadway improvements in the area. They're improving the water quantity and quality. They're maintaining all the setbacks and increasing buffers and the existing landscaping. So I'm equally torn on this. Commissioner Cohen?
Yeah, thank you, Mr. Chair. Normally, we don't speak after you, but it sounds like the board is somewhat divided. And where I am on this, I think is closer to where our staff came out on it, and that is that the size of the improvements is very significant. The road improvements and also the promised water quality improvement, which, you have to take into account. These are major investments that are being made into the property. So I understand everybody being torn, but I think I'm tending to lean in the other direction.
Commissioner Owen?
Yeah, I'm just going to move for approval.
Second.
Okay, we got a motion to approve by Commissioner Owen, second Commissioner Myers. Any other comments? Commissioner Kemp?
I just make a motion to remand. And the reason would be to give some, and I understand the investment and the challenge of the property, but I'm wondering if there can be something done to reduce the scale and intensity a little bit and still make value of the property and the necessary improvements. So I'll just put that out there and to see if there could be a little bit of reworking to, make this change more accommodating and work for the residents as well as the investor applicant.
Adam, let me ask you, do you see, and I'm going to ask the applicant the same thing, do you see any potential value in a remand?
Well, Commissioner, if the applicant was amenable or willing to consider a remand, there certainly could be value in that. We're supportive of the application, understand the board's feelings on this, but certainly if the applicant were amenable to remanding and reducing entitlements, that's something that we could certainly accommodate and perhaps would go to address some of the Planning Commission comments.
Okay. Ms. Grimes?
Yes, Gina Grimes for the record. Appreciate your suggestion, Commissioner. However, we did already evaluate that issue about reducing the scale because of the residents' concerns. However, what we did was kind of on the opposite end. We'll keep in mind first that it's a 0.25 FAR that we're adhering to. But we thought on the other end, the compatibility measures that we were agreeing to mitigated for that any potential impact. And so we thought, given that we are already at a low FAR of 0.25, and given that we have quadruple the amount of setbacks and buffering that we're otherwise required to have, we thought that compensated for that. So, yeah, a remand to reduce the entitlements is not viable.
Okay, so we have a motion to approve. Commissioner Owen, second Commissioner Myers. Please record your vote.
Do a point of order real quick. Did Commissioner
Again, we
Kemp?
got a
She did.
second.
Okay.
So it died. All right, please record your vote.
Motion carried 4-3. Commissioners Cameron, Cepeda, Kemp, and Wostel voted no.
Okay, thank you. Next item.
Commissioners, the next item is agenda item F3, rezoning PD 23-0519. The request is to rezone a 1.69 approximate parcel that's located in the northeast corner of Bierce Avenue and East 148th Avenue. The request is for 11,600 square feet of medical office uses. Again, here's the location of the property. Surrounding zonings include mini warehouse to the south, industrial to the north, and commercial neighborhood zoning to the north that's developed with a similar use. Staff is recommending approval. The issue regarding, you'll notice there's an inconsistency found in Planning Commission is related to compliance with commercial location criteria and caps within the location criteria that through those caps limited to 5,000 square feet. The applicant is just requesting relief from that via the exception language in the commercial location criteria for office uses on parcels not viable for residential. Again, staff is recommending approval. The hearing officers recommend approval, but Planning Commission didn't find any inconsistency due to those issues regarding the square footage caps in the commercial location criteria. We're available for any questions. Thank you.
All right, thank you. Good morning.
Good morning. Cami Corbett again with the law firm of Hill, Ward, and Henderson, representing the applicant, which is Tampa Family Health Centers. They provide health services. We could switch to the PowerPoint. They provide health services throughout Hillsborough County. Just a little background in this site. Tampa Family Health Centers originally purchased the site outlined in blue in 2019 and developed the existing 11,400 square foot medical office building. They then purchased in 2021 the CI parcel that is fronts on Bears Avenue, and this is Bears Avenue, right where it curves between where it turns into Nebraska. And then they were, in 2023, had the opportunity to buy the parcel that's zoned RMC6. And so what you're seeing this morning is a PD rezoning of the CI parcel and the RMC parcel to allow for an additional medical office. And you can see this is an aerial of the existing development. You can see they built their existing medical center and they developed that CN parcel with parking for overflow parking for that medical office. And the request before you is for an 11,600 square foot medical office, which is a 0.16 FAR. It's a building height of 20 feet. We are asking for one variation to allow for 4.59 parking spaces per 1,000, which is consistent with other variations that you've previously approved. This would normally be 5 per 1,000, but we're asking for 4.59. One of the reasons we're asking for the variation is actually when these parcels are taken together, there's actually more than enough parking for both parcels, but we want them to stand alone from a zoning perspective, so we're asking for the variation here. The staff reports, if you look at compatibility and with the surrounding neighborhood, both Development Services and the Planning Commission find the use is compatible with the surrounding area. And as Brian pointed out, the biggest issue is commercial locational criteria. And we cited many reasons in the record as to why we disagree with the Planning Commission staff on their finding, but the primary one is the one that Development Services cited, which is there's an exception for office uses in the Comprehensive Plan Policy 22.6, when the office is providing a buffer between existing commercial uses and residential, and when we're zoning through a PD. And that is a policy that the zoning hearing master relied upon as well. This is a unique location. You can see this is how Bears Avenue sort of snakes east and west, goes north and south in one location, and the east-west roadway that they're calling the major local roadway that they're trying to satisfy commercial locational criteria really doesn't provide access to any neighborhood. One of the whole purposes behind commercial locational criteria is to keep commercial traffic off of local roadways, and although this is technically classified as a local roadway, it's really not serving the same function that a normal neighborhood local roadway would serve. Also to point out, we have commercial uses by right. The CI parcel allows for up to 7,600 square feet of either a convenience store with a gas pump, a contractor's office with open storage, a restaurant, or drive-through. And the RMC6 parcel could be a 10,890 square foot school, church, or daycare. And therefore, we think that the proposed request is more consistent and compatible with the surrounding area, and we would respectfully request your approval.
All right, thank you. Anyone here in support of the application? Anyone in opposition? Planning Commission?
Thank you. For the record, Melissa Leinhard, Planning Commission staff. The subject property is located in the Residential 6 future land use category. It is in the urban service area and not located within the limits of a community plan. The Residential 6 future land use category surrounds the subject site directly to the north, east, and south. West of the site past Bears Avenue is light industrial. Further east is Residential 12 and public quasi-public, and further south is Residential 20. The proposal is consistent with Objective 1 and Policy 1.4 of the future land use element, as it encourages compatible growth within the urban service area. The request is also consistent with Objective 16 and its associated policies pertaining to neighborhood protection. And the revised site plan submitted on August 2nd, 2023 depicts adequate transitions of intensities between adjacent land uses, thereby meeting the intent of this policy. The subject site is located with Residential 6 and therefore subject to commercial locational criteria requirements for non-residential uses. The subject site meets commercial locational criteria as it's located within 300 feet of the nearest qualifying intersection of Bears Avenue and East 148th Avenue. Based off of the site's proximity to the qualifying intersection, it is limited to a maximum of 5,000 square feet of non-residential development, and this is based on the scale of roadways. The proposed total square feet exceeds this maximum and therefore directly conflicts with the established commercial locational criteria. While FLU Policy 22.8 contains language that allows for a waiver to locational criteria, language in the same policy explicitly states that square footage requirements of the plan cannot be waived. Therefore, the proposed square footage that is part of the application cannot be supported, as it is inconsistent with the specific language outlined in this policy. The applicant mentioned Policy 22.6, which is an exception for office uses outside of meeting commercial locational criteria. Because this site does meet commercial locational criteria, this policy does not apply in this scenario and could not be considered by staff at this time. Although Planning Commission staff has minimal compatibility concerns with the nature of the request, the proposed square footage would allow for development that is inconsistent with the goals, objectives, and policies of the comprehensive plan. And based upon those considerations, Planning Commission staff finds the proposed plan development inconsistent with the unincorporated Hillsborough County Comprehensive Plan. Thank you.
All right, thank you. Hearing master.
The zoning hearing master considered the applicant's request to rezone the property that is the subject of this application to a planned development to allow development of 11,600 square feet medical office building. The proposed FAR is just under 0.16 and is less than the maximum 0.25 FAR of the residential 6 future land use designation. The applicant's site plan shows a 20-foot wide buffer and type B screening along the property's north and east boundaries adjacent to residential and place of worship uses, and 8-foot wide vehicular use area buffering along the subject property's south and west boundaries, and scenic roadway plantings along the west boundary adjacent to Bierce Avenue. The applicant requested a design exception for substandard roadway improvements on 148th Avenue, which the county engineer found to be approvable. If the rezoning is granted, the county engineer will approve the design exception, and the developer will be required to widen the roadway travel lanes to 12 feet from the project access point to Bierce Avenue. The applicant requested an administrative variance from Land Development Code Section 6.04.07, access spacing, to require a minimum of 50 feet between access points on 148th Avenue. This administrative variance was also found to be approvable by the county engineer. The applicant's request regarding the PD variation to Land Development Code parking and loading was also considered by the zoning hearing master and found to be consistent and supportable, as well as transportation staff recommendation of approval of the PD variation with the condition that bicycle parking is provided at a rate of 5% of the required 5 spaces per 1,000 square feet of gross floor area. The zoning hearing master concurred with the Development Services Department's recommendation of approval of the application and recommended approval.
All right, thank you. Commissioner Myers, were you in the queue?
Yes.
I think I accidentally eliminated you.
I was in the queue waiting until we finished.
Oh, okay.
Yeah.
Commissioner Owen?
Thank you, Mr. Chairman. And I look at this, Mr. Gormley, and I see that it's just peppered with compatibility. This seems like a medical kind of center area, correct?
Yes, that's the way we're viewing this, yes, sir.
Yeah, and Ms. Leinhardt, you were addressing, because I was looking at 22.8 and 22.6. That was really your biggest issue, is that there was no wiggle room pursuant to the rules on this, so you were kind of confined in a box on this one. Is that safe to say?
Yes, sir, that is a correct assessment. Policy 22.8 expressly says the square footage may not be waived. So that is actually part of the waiver policy that says you can waive locational criteria, but there's a chart associated with each roadway. So whether a 2-lane roadway or a 4-lane roadway, it gets pretty complex.
Yeah.
But essentially that square footage limit, which is based on the scale of the roadway. So as the roadways get bigger, the roadways are wider, there's more travel, then the scale of the allowed development gets bigger with it. And then of course, it's cinched down when it's a major local roadway, which this is. So the 5,000 square foot cap is what the cap is for this one.
Sure, and I just think that's important just to see, for the public's purposes, how planning and development services, the different confinement in the boxes that each of you all work within. And I think ultimately why this board is here is to make these decisions. And I think that, again, this is not my district, but I do think that this is, the compatibility is just there on this particular property. And I tend to lean on development services estimation on why this should be approved, while completely understanding planning the confinement they have based on procedure. So I'm inclined to support this, but again, it's not my district, so I'll sit back and listen.
Commissioner Myers?
Thank you, Mr. Chair. I'm going to go ahead and move for approval, but I also want to say that Tampa Family is one of the federal healthcare qualified centers we have, and they are located within my district. Many of their facilities are in District 3, where they're serving low to moderate income, and I know we're speaking of 11,600 square feet. So to make an exception, I appreciate your comments and gone to the Planning Commission, but this is one we must approve. Thank you so much.
And I just want to say that Commissioner Myers brings up a great point, that Tampa Family Health Center provides a wonderful service. I drive past this area every day, and it's clearly a appropriate use. And I will point out that Planning Commission found, I think, all the other points consistent with the comprehensive plan, with the exception of this one of the size area. So I'm happy to support it. So we get a motion and a second. Please record your vote.
Motion carried, 7-0.
All right, thank you. Next item.
Next item is agenda item F4. It's rezoning PD 23-0522. This is a project that's located in the Riverview area on the south side of Simmons Loop, south of Big Bend Road, west of US 301. The request is ostensibly to combine an existing PD and add two additional parcels which are located in the southeast corner of their property into the existing PD to create a new PD. The existing PD is approved for a total of 750 units consisting of single family, and also allows for multifamily or townhomes or assisted living facility. Again, this is a site plan. The road in the middle is an extension of Simmons Loops that traverses south through another PD and will provide connectivity further south and options for alternative routes to get to 301 and east and west. Again, the area of modification on the east side of that roadway is the area where, as part of adding those additional acres, they'll increase the total unit counts by 200 units, which would accommodate up to 600 multifamily or 400 townhomes. The allowances for charter school, which in this PD and the existing PD that's being added to this PD are being removed as part of this request. Staff has recommended approval, is found consistent by the Planning Commission, and the hearing also recommended approval, and staff's available for any questions. Thank you.
Thank you, and I can see the applicants here. You may proceed.
Cami Corbett again for the record with the law firm of Hillward and Henderson. Brian covered most of it, but I do have a couple graphics that I'd like to share to maybe slow it down and show you a little bit of what he's referencing. Again, the site is located south of Big Bend. So this entire property has been entitled for quite some time, with the exception of the purple add-on parcels. Back in 2020, there was a modification to what's called Simmons Village North, which is the property in the yellow, and Simmons Village South, which is the property in the green. And those are entitled for single-family homes. And so this PD is comprised of the yellow Simmons Village, the blue modification area, which is the area that's already approved, and the purple add-on parcels. And this is the PD plan, and everything in the yellow to the west is approved and under construction right now for single-family development. And then the green is the alternative land use pocket. And this is in the SMU 6 future land use category, so it does require us to have both single-family, multifamily, and townhomes to meet those plan policies. So the green is where the multifamily and the townhomes would occur. We also have assisted living facility. In that alternative land use pocket and the add-on parcels, there are actually currently, before this request, 2 charter schools that are approved, one on the add-on parcel and one in the PD. And part of what we're doing is removing both of those charter schools from this approved PD. So we're adding the acreage, and we're removing the charter school, and we're adding an additional 200 units. We have findings of compatibility and consistency from both Development Services and the Planning Commission, and we'd respectfully request your approval. We're here to answer any questions should you have any.
All right, thank you. Anyone here in support? Any proponent testimony? Any opposition testimony? Okay, Planning Commission?
Thank you. For the record, Melissa Leinhard, Planning Commission staff. The subject property is located within the suburban mixed-use 6 future land use category. It is in the urban service area, and it is also located within the Riverview Community Plan, as well as the South Shore Area-Wide Systems Plan. The subject property is surrounded by SMU 6 on all sides, and the residential 4 future land use category is located further east across US Highway 301. Each of the development options would encourage compatible residential growth within the urban service area, making the proposal consistent with Objective 1 and Policy 1.4 of the future land use element. The maximum allowable number of units for each option are also within the limits of the site's suburban mixed-use 6 designation, making the proposal consistent with future land use element Objective 8 and its associated policies. The proposed rezoning meets the intent of Objective 16 of the future land use element and its associated neighborhood protection policies. The request includes development options that are complementary to the surrounding area, and the density, lot sizes, housing types, and increase in acreage will preserve and enhance the surrounding area and are therefore consistent with this policy direction. Objective 19 and Policy 19.1 of the future land use element establish requirements for mixed-use future land use categories. Each of the development options qualify as the additional land use to the proposed 250 single-family lots and are therefore consistent with this policy direction. The request also meets the intent of the Riverview Community Plan, which encourages attractive residential development and housing diversity. It is also consistent with the economic development objective of the South Shore Area-Wide Systems Plan. Based upon those considerations, Planning Commission staff finds the proposed plan development consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the conditions proposed by Development Services. Thank you.
Hearing Master.
The zoning hearing master considered the applicant's request to rezone the subject property to a unified plan development to allow the area west of Gate Dancer Road to be developed with 250 single-family lots, to increase the acreage of the area designated on the applicant's site plan as alternative land use pocket, and to allow the alternative land use pocket area to be developed with any mix of up to 600 multifamily units, 400 townhome units, or nursing home and extended care facilities at a maximum density of 6 units per acre. The applicant is no longer proposing the charter school that was approved in Plan Development 22-440. As you've heard from Planning Commission staff, from Ms. Leinhard, Planning Commission staff did find this proposed plan development to be consistent with the comprehensive plan, encouraging development that complements the character of the surrounding area and consistent with the goals, objectives, and policies of the comprehensive plan. Development Services Department also found the requested plan development zoning to be compatible with the existing zoning and development pattern in the area. And the zoning hearing master recommended approval of the request.
Commissioner Owen.
Thank you, Mr. Chairman. And Commissioners, this is a kind of a real critical road to St. Joe's. And I know that, Mr. Gormley, we've had lots of communication with the hospital. I know I've met with them personally a couple times because of their concern with Simmons Loop. And they concede to this type of change because looking at it, and my understanding is that with the charter school, you're talking about a lot more peak hour trips compared to what the single-family residential is going to bring to the community, correct?
That's correct. This change represents a significant reduction in potential traffic from what's currently approved and, as you correctly stated, largely related to the removal of the charter school.
Gotcha. And the connection, this is going to bring a full connection of the road from Simmons Loop to the flyover? Is that what this is going to do?
Yes, sir. This project will continue the connection from Simmons Loop Road down to Paseo El Mar. Paseo El Mar then has a flyover to over the interstate to get to 41. It could also get to 301. So it will, the road segment that's under construction will complete a significant network improvement for that area.
Yeah, very good. Yeah, so I'll move for approval on this.
Okay, we've got a motion to approve. Commissioner Owen, second Commissioner Kemp. No other comments. Please record your vote on F4.
Motion carried, 7-0.
All right, next item.
Commissioners, next item is F5. This is the Patterson Road residential plat approval, and Adam will speak to this item.
Yes, Commissioners, item F5, this is the final plat for the Patterson Road residential project. This plat was originally on the September consent agenda and was removed from consent and continued to the December meeting to allow the time for the pending lawsuit at that time to play out. Come the December hearing, the trial had been held, but a judgment had not been entered, so the item was continued again to the January meeting. At this time, the county has received a judgment, and it was in favor of the county and Taylor Morrison for the majority of the counts. There was a portion of the order that prohibited the construction of a stub out to an ag zone piece of property just north of the PD that was included in the subdivision. The plat that's before you today does not impact that area at all. There was no interest being platted there, and so we reviewed the judge's order and determined that there was no change necessary to the plat in order to be in compliance with the judge's order. So it is in order for the board to act on today. This will establish the lots within the project as legally established lots and provide for the acceptance of infrastructure that goes with the construction of the project. I'm available for any questions. We do have representatives of the county attorney's office here should there be any questions regarding the status of the litigation, but it is an order for the board to act on, and this is an item that would normally be on the consent agenda. However, it's on the regular today only because of being pulled from consent previously. So available for any questions.
All right, thank you. Commissioner Wostel?
I think that we've been very sensitive to this difficult topic, but ultimately we are here to enforce and follow the law. We're not here to override it. And if we have a judge, a duly bodied judge, saying that in line with the law, they are entitled to continue to move on, I think that while extremely difficult, we've tried to be as sensitive as possible. So I don't see, I would love to hear of any other paths forward, but at this point, I just feel like it has to move forward, and there's nothing that, we're not here to violate the law, we're here to support it, and the judges spoke.
Commissioner Cohen?
Commissioner Wassel, I agree with you completely, and I concur with your sentiment. I think at this point, we are essentially a ministerial body, and we need to move this along.
Okay. All right, so we got a motion by Commissioner Cohen, a second by Commissioner Myers, and I'm just going to say, unfortunately, I agree with Commissioner Wostel and Cohen. I'm the one that pulled the items both times. I'm the one that led the charge and made the motion to delay until the court ruled, but I don't believe, and I want to ask Adam this, or Joanna, I don't believe we have a legal basis to deny or to delay the recording at this point. Is that accurate?
Yes, Commissioner, I would say at this point, the outstanding question that the board is very sensitive to has been answered. I would agree with the sentiment that this is essentially a ministerial action at this point on the board's behalf.
Okay. All right, we have a motion and a second. Please record your vote.
Motion carried, 7-0.
All right, thank you. Next item.
Commissioners, the next items are related items, G2A and G2B. G2A is a request to rezone an 8.8 acre parcel. This is from RSC 6 PD and AS1 to Plan Development. This is in the Greater Palm River area on the south side of Causeway Boulevard, west of US 301 and east of 78th Avenue. And again, the request is to rezone to Plan Development to accommodate a maximum of 238 multifamily units. To accommodate the unit count, they're asking for a flex of the Res 20 plan category that's to the immediate east. That parcel to the east is to approve for multifamily uses. And then they're also asking for a gray water density bonus pursuant to statutes that allows for density bonus and on top of it, minimum densities via the recycling of gray water on site. Staff is recommending approval of the rezoning action. The related item G2B, I would note that Planning Commission also found the rezoning consistent, and the hearing officer also is recommending approval. The related item G2B is a minor modification to basically the northern half of this parcel is being rezoned out of existing planned development. So the PRS is to memorialize, if the zoning is approved, the removal of the northern half of the property from the existing PD and memorialize the uses to remain, which is basically a FDOT retention pond. Therefore, staff is recommending approval of both G2A and G2B, and we're available for any questions. Thank you.
All right, thank you. Applicant here?
Cami Corbett again with the law firm of Hill Ward Henderson. I don't have anything additional to add. I think it's a pretty straightforward request. This would be on consent, but for the fact that we have the PRS as an additional item. So we're here to answer any questions should anybody have any.
All right, thank you. Anyone here in support, any proponent testimony, any opponent testimony? Planning Commission?
Thank you. For the record, Melissa Leinhard, Planning Commission staff. The subject property is located within the residential 9 future land use category. It is in the urban service area and also located within the limits of the Greater Palm River Community Plan. The proposed rezoning is consistent with Objective 1 and Policy 1.4 of the future land use element, as it would encourage compatible development within the urban service area. The area contains a mix of uses, including single-family residential, multifamily residential, and public institutional uses. The applicant requests a flex with the adjacent future land use category of residential 20 that's located to the east. The second and third development options incorporate the Florida gray water density bonus in addition to the flex request. In coordination with the Hillsborough County Attorney's Office, Planning Commission staff have determined that the Florida statute pertaining to the gray water density bonus is a non-discretionary bonus and may be applied and considered along with the application of a flex request under Policy 7.3 and 7.4 of the future land use element. The proposed modification meets the intent of future land use element Objective 16 and several of its associated policies related to neighborhood protection. The proposed multifamily development would complement the existing range of residential development in the area, and the subject site is located along an arterial roadway in the urban service area, which is a preferred location for high-density residential development. The proposal will also ensure a gradual transition of residential uses between Causeway Boulevard and the single-family units that are located south of the subject site. The proposal is consistent with the intent of the Greater Palm River Community Plan. The proposed development will meet the community plan's goals of encouraging well-designed, compatible densities and intensities at appropriate locations. Based upon those considerations, Planning Commission staff finds the proposed plan development consistent with the unincorporated Hillsborough County Comprehensive Plan, and that will be subject to development services conditions. Thank you.
Hearing Master?
The zoning hearing master considered the applicant's request for rezoning of the subject property to a planned development to allow a multifamily residential project. The applicant is requesting application of future land use policies 7.3 and 7.4 to flex the residential 20 future land use designation on adjacent folio to the east and to allow 3 development options. A companion minor modification has been submitted to remove folio 47, 45, 46, 100 from PD 85 to 62. The zoning hearing master noted that the applicant is proposing a maximum building height of 60 feet along the subject property's south and east boundaries. The development will comply with the requirement of the code that structures be set back an additional 2 feet for every 1 foot of height over 20 feet. The applicant is requesting a waiver from the additional 2-to-1 setback requirement along the property's north boundary abutting Causeway Boulevard and the west boundary abutting 86th Street and the FDOT stormwater retaining area. The applicant is proposing a 34-foot setback along the property's west boundary and a 30-foot setback along the north boundary. The zoning hearing master considered those requests and found them to be compatible and consistent with the comprehensive plan and the code. And development services staff also found the requested plan development zoning compatible with the surrounding area, which the zoning hearing master noted, as well as the planning commission staff finding that the proposed plan development would allow development that is consistent with the comprehensive plan and compatible with the surrounding area. The zoning hearing master concluded with a recommendation of approval of the plan development rezoning.
Okay, we'll defer the vote until after we hear the minor mod presentation. Does the applicant need to add anything on G2B?
Cami Corbett for the record. No, I do not unless there are any questions.
Okay. Any proponent testimony on the minor modification, PRS? Any opponent testimony? Or if not, can we have a motion on both G2A and G2B?
So moved.
Second.
Motion by Commissioner Cohen, second Commissioner Myers. If no comments, please record your vote. G2A and G2B.
Motion carried 7-0.
All right. Last item.
Last item is related items G3A and G3B. G3A is a request to rezone a 4.31 acre parcel that's located in the university area, again, just east of the University Mall site, again, west of Bruce B. Downs area. The request, again, is to rezone to a planned development. They're seeking a maximum of 215 units with a maximum 807 residents for a student housing project. That's also incorporating within the first floor a 1,550 square foot retail component. Is part of a request for a mixed-use density bonus. The applicant is requesting a flex of the UMU 35 future land use category that's on the parcel to the east, and in addition to that, then also requesting a mixed-use density bonus to get up to the 50 units per acre required to accommodate the 215 units. As you'll note, it has not support recommendations from our staff and the Planning Commission. The issues regarding non-support have to do with compliance with an application of applicable policies within the comprehensive plan regarding the provision of the flex and also utilizing of the density bonus on top of the flex, and then also compliance with minimum square footage standards for second uses as part of the mixed use plan categories. And so based on those issues, Planning Commission found it inconsistent based on both those issues, and our recommendation was more focused on the non-compliance with the minimum percentage requirement. But I will note that the hearing officer did recommend approval based on the applicant's arguments regarding compliance with those policies. Staff's available for any questions regarding G3B. That's the related item because they're zoning this parcel out of an existing PD, notwithstanding the recommendations of staff and Planning Commission. If the board were to recommend approval of G3A, staff did find G3B be approvable. Again, it's a ministerial action to show removal of this parcel from the existing PD that it's located within. We're available for any questions. Thank you.
All right, thank you. The applicant here. Good morning, sir.
Good morning. My name is Colin Rice, the law firm of Older Lundy, here on behalf of the applicant. I've got two basic visuals for you. This is in the record from the zoning hearing master hearing. So, good morning again. I'm here on behalf of LDC Acquisitions, Plan Development Rezoning, 215 dwelling units on approximately 4.3 acres in the University Community Area. I'm joined by Chase Powell and Madison Whitaker from Landmark Properties of the applicant group. In short, we respectfully request you adopt the very thorough findings and recommendation of approval from the zoning hearing master from November 13th. So showing you here just a simple visual to orient you and share what this community looks like. So in short, this is a nearly identical development to what we'll call the standard, which is a sister property directly to the east. It's here. It's the same density, the same ownership, and the same operation. This was approved in 2017. It used the same mixed-use density bonus, and we'll get into that a little bit later. So the county needs increased density in the appropriate places. This is such a place. It is directly between University Mall and the University of South Florida. There was no public opposition to this project. In fact, we held a neighborhood meeting. Mr. Powell attended with me. We had longtime residents of the community to the north who were supportive and complimentary of the existing operation of the standard. In leading up to the zoning hearing master hearing, and we'll touch on some of Mr. Grady's notes from the introduction, lengthy discussion with staff, several memoranda put into the record concerning a couple of comprehensive plan policies. So of course, we use the flex provision in policy 7.3 to extend the boundary of RMU 35 here over our sites. From there, we use comprehensive plan policy 19.1 to get up to 50 dwelling units an acre. I'll note that nothing in the record suggests that we have not qualified for the flex. We have. So the zoning hearing master found specifically that Planning Commission staff and Development Services staff found the standard consistent and approvable in 2017, this project. That the standard offered less than 1% of the overall site as a second use. That the plain language of the comprehensive plan's mixed-use density bonus provisions does not require properties under 10 acres to allocate 10% of the site to a second use. That our project's application of the flex provision is consistent with the plain language of the comprehensive plan. That our project's application of the vertically integrated mixed-use bonus provision is consistent with the plain language of the comprehensive plan. And I'll read you two specific points. This is from page 27 of the zoning hearing master's recommendation. Paragraph 24. There appears to be no comprehensive plan provision that prohibits application of a mixed-use density bonus to a parcel on which a land use designation boundary has been extended through the comprehensive plan's flex provisions. Paragraph 25. The applicant's request to apply the comprehensive plan's mixed-use bonus provisions appears consistent with the past interpretation of these policies by Planning Commission staff and Development Services staff. Lastly, of course, the zoning hearing master found all variations approvable and ultimately recommended overall approval of this site. Again, this is from zoning hearing master record. This is the standard. This is almost exactly what will go in the proposed project today. Again, thoroughly vetted, full evidentiary hearing, memoranda, legal interpretation in the record. Nothing in the land development code, nothing in the comprehensive plan prohibiting the mechanism by which this project arrives at 50 dwelling units an acre. And clearly, the 10% non-residential component does not apply. That only applies for properties greater than 10 acres. We are 4.31 acres. Does not apply. So to conclude, the laws applicable to such decisions have to be read consistently. This is a good project. It's putting density where it is most needed, and it mirrors an incredibly successful, contributing, compatible, non-disruptive project to the immediate east. We're replacing an old, outdated commercial strip center. We're actually reducing vehicular trips. So we again respectfully request your approval. Available for any questions now or during my rebuttal time, and I want to make sure that our rebuttal time is set following presentation from staff and Planning Commission staff. Thank you very much.
All right, thank you. Anyone here in support of the item? Anyone in opposition? If not, Planning Commission?
Thank you, Melissa Leinhardt, Planning Commission staff. The subject property is located in the Office Commercial 20 Future Land Use category. It is in the urban service area and also located within the limits of the University Area Community Plan. The subject site is surrounded by Residential 20 and Residential 6 to the north, Regional Mixed Use 35 to the east, Office Commercial 20 further to the east and south, and the Innovation Corridor Mixed Use 35 Future Land Use category to the west. The applicant proposes to flex the adjacent Regional Mixed Use 35 or RMU 35 category that is located to the east in accordance with the Future Land Use Element Policy 7.3 and also 7.4. A flex does not ultimately change the future land use map category and therefore cannot be used as a base for a bonus within the comprehensive plan. Rather, it is something above and beyond what is underlying as the maximum density and intensity for a site. Base densities and intensities are established by the future land use map and can only be changed through a comprehensive plan map amendment. While the density and intensity of the RMU 35 future land use category may be compatible with the surrounding land uses and their densities and intensities, the overall request does not further the goals, objectives, and policies of the plan by trying to circumvent policy direction. The proposed rezoning does not meet the intent of the neighborhood protection policies of the future land use element. There is no way to ensure a gradual transition in intensity between land uses with all the variations that are being requested as part of this plan development. Due to the intensity of the proposed uses encroaching into the residential uses adjacent to the north, Planning Commission staff does not support multiple variations based on conflicts with several comprehensive plan compatibility policies. The community design component discusses how new development shall be compatible with the established character of the surrounding area, and it encourages commercial developments that enhance the community's character. The development pattern and character in the area of the University Square Mall does contain a mix of uses with commercial and residential developments, as well as single-family to the north. However, the proposed site design and variations present compatibility concerns and therefore conflict with this policy direction. The proposed plan development meets the intent of goals 2 and 5 of the University Area Community Plan, as it includes a redevelopment opportunity within the urban and infill redevelopment area map. However, goal 3 of the plan aims to use landscape buffers and urban design features and techniques to reduce conflicts between land uses. The proposed density in the OC 20 future land use category and the proposed site design variations may not provide the opportunity for a gradual transition between the single-family residential development to the north. And based upon those considerations, Planning Commission staff finds the proposed development inconsistent with the unincorporated Hillsborough County Comprehensive Plan. Thank you.
Hearing master.
The zoning hearing master considered the proposed rezoning of the subject property consisting of approximately 4.31 acres at 2700 University Square Drive. Excuse me. The applicant is requesting to rezone the property to a planned development in order to allow a vertically integrated mixed-use project with 215 student housing dwelling units with 807 beds, 1,550 square feet of ground-level retail space, 3 courtyard areas with a total of nearly 18,000 square feet, a lobby, leasing amenity space, and a rooftop amenity level. The applicant is requesting application of the comprehensive plan's flex provisions and mixed-use bonus provisions to achieve the proposed density of 50 dwelling units per acre. The zoning hearing master considered these plan provisions and made the following findings: that the applicant's request to apply the plan's flex provisions to extend the boundary of the residential 35 land use designation on the adjacent folio to the subject property appears consistent with the plain language of the comprehensive plan's flex provisions at future land use objective 7 and related policies. The applicant's request to apply the mixed-use density bonus to achieve a density of 50 units per acre was found by the ZHM to be consistent with the plain language of the comprehensive plan's mixed-use density provisions at future land use objective 19 and related policies. Additionally, the zoning hearing master stated that there appears to be no comprehensive plan provision prohibiting the application of a mixed-use density bonus to a parcel on which a land use designation boundary has been extended through the comprehensive plan's flex provisions. The zoning hearing master also stated that the applicant's request to apply the comprehensive plan's mixed-use bonus provisions appears to be consistent with the past interpretation of these policies by Planning Commission staff and the Development Services Department staff. The zoning hearing master also considered the requested plan development variations and found them to be supportable. The zoning hearing master concluded with a recommendation of approval of the rezoning request.
All right, we're going to defer the board discussion and vote till after we hear the PRS. Does the applicant need to add anything for G3B?
Nothing for G3B. May I be afforded a moment to address the testimony from Planning Commission staff?
No, sir. I already asked our county attorney, and the rules don't allow that. So if you would have had an opponent here, you could have rebutted it. But anything on PRS?
Nothing further companion to the PD.
Thank you. Anyone here in support? Anyone in opposition? Commissioner Owen?
Thank you, Mr. Chairman. This is another interesting one, Ms. Leinhardt. You know, for me, looking at this, you know, there's really 3 questions. You know, can they flex? Is the 10% for density bonus a hard, fast rule? And is there compatibility? Those are the 3 things I really looked at when I took a deep dive into this. And, you know, I'm having trouble finding why they can't flex, Ms. Leinhardt, on this, pursuant to, you know, comp plan policy. Can you, take a deeper dive into that? Because I looked at it and I didn't see where they can't flex pursuant to our comp plan policy. Could you please?
Yes, sir, I'm happy to address that. Melissa Leinhardt, Planning Commission staff. So a flex and a bonus are two different things. The flex provision is a consideration that's allowed. It is not a guarantee. There are 3 tenets. The third one is typically the most difficult to prove, and that's advancing the goals, objectives, and policies of the plan. So typically, if you, say for instance, were in a residential plan category and you had to meet commercial locational criteria, someone could ask, say you're on Causeway Boulevard, I'm just making this up. Someone could ask to flex the UMU 20 category that's across the street, and that doesn't meet commercial locational criteria. In those general terms, we typically don't support those kind of proposals that are trying to circumvent their existing land use category to get around a requirement. So that's an example of where the third tenet would not be met. In this case, they're asking for a flex and a bonus on the same property. We as staff have supported a flex and a bonus within the same project, but not over the same landmass. So they're asking to basically double dip and use the base layer as the flex increase, but that's not the future land use designation of the property. That is it's an allotment that you can use for up to 500 feet parallel to an existing land use category that is surrounding your subject property. So what we've done with projects in the past, we've said, sure, you can use a flex and a bonus, but the flex is only for the first 500 feet, and then you can use the bonus on the subsequent acreage. And that is how we've brought them before you in the past. This applicant, even though we explained that, this applicant just decided to push forward with what they believe the policy says. And our standing is that a flex and a bonus, the bonus is a discretionary bonus. It's a mixed use bonus, so there are requirements for that. And getting to the 10% rule, we're updating the future land use element right now, as you know. But one of the things that we've noticed, my team in the past with doing consistency reviews, is under Objective 19, which is where the mixed use policies are. 19.1 talks about if you're in a mixed use category, you have to provide for a mix of uses if you're a certain acreage, right? So if you're in SMU 6, it's 20 acres. If you're UMU 20, it's 10 acres. And that's basically trying to have a meaningful mix of uses within the future land use category and within the development. 19.3 is where the bonus is. So they're separate policies, right. And we recognize that there's not an innate connection between the two. But in the past, we have used, and for a very long time, we have been using the 10% minimum rule that's outlined in 9.1 in 19.3 as a guideline. Because if the policy says that 10% is good enough for a mandatory mix of uses, why would we not use 10% as a meaningful mix of uses for the bonus? It seems transferable and logical, and that's what we've used in the past. Now, before Senate Bill 250, we really wanted to clarify that, and then it kind of fell off the table. It's a change that we have on our docket to look at for the future. But essentially, this applicant is only providing 1,550 feet of retail when the total square footage of the building is 187,926,000. So that does not meet the 10% rule, and I would argue is not a meaningful mix of uses in order to gain a bonus, which is above and beyond the future land use category. That should be a quid pro quo. You are giving something to get something. And in this case, we are not supportive of it. Does that help?
It helps a lot. You did a great job on that. I guess I was just unpacking the flex and density bonus separately because I was just trying to, and you unpacked them together, which I completely understand you doing that. Mr. Gormley, I don't see where it necessarily violates the comp plan policy itself on flexing. So can you address what Ms. Leinhardt was just stating too and give your position?
Yes, we had a little different read on that. The way we're reading the comprehensive plan is that the flex allows an actual flexible boundary for that future land use category. And through the planning process, the PD process, that boundary can be extended up to that 500 feet. So we're looking at that as an actual extension of the boundary. We don't read that to say that the density can be used, but the future land use category is not otherwise applicable. So we didn't see anything that would say that can't be used for density calculation purposes, and rather the language seemed to support that the actual future land use category was changing, and that would make that the new base for the purposes of that of the application. And that was the basis for our recommendation on this one.
And on to the density bonus, and I know words like discretionary were used on this, and I'm trying to look to see if there is if it is a hard, fast rule we have to follow on the density bonus. The 10%, is that, which in your position, a hard, fast number, or could you allude to that a little bit?
Yeah, sir. We're not looking at that as a hard and fast number, much like the Planning Commission. We're looking at that as guidance as to what level of mix should be included. As Ms. Leinhart stated, if this was a RMU 35 category and 5 unit, 10 acres or larger, they would be required to have a mix of uses. That mix would require a 10%. For the vertically integrated incentive density bonuses, there is not that metric in there. It's not a hard and fast number that's in there. Our recommendation was based on looking at the 10% for the mixed-use categories, and that was the basis for our recommendation.
Yeah, when I look at the property to the east, I mean, the guidelines that are being applied right now, let's just say by planning, was that the same for the property to the east? Because I just see and that brings me to the third prong that I'm looking at. I'm sorry for talking like a lawyer, but I look at that compatibility as the third thing, and I say, well, gosh, the property to the east, it doesn't look like that same standard was applied. And two, I see that not only is this type of housing appropriate because of student housing, I also look at the future of this area, which looks like more student housings to come. So could you touch on that real quick?
Yeah, so the site to the east actually had it didn't require a flex.
Okay.
So that element wasn't in there. In terms of the density bonus, it was granted a density bonus, and it was granted in a similar allotment of the second use as this. I don't know if it's exactly numerically the same, but it was considerably under 10% for that project. In terms of compatibility, we looked at this. Our recommendation did not include any finding of incompatibility with the surrounding area. This is the type of development pattern that we are seeing along this road and in that general area, and we're supportive of it from a compatibility standpoint. Our recommendation only hinged on the amount of the non-residential.
Yeah. Well, great job, both of you. It explains a lot. I really found this a very interesting fact pattern for this particular project. Just because of the compatibility, and like I said, I've viewed the comp plan and the density bonus as not necessarily being a hard, fast rule. I'm really inclined to support it. Again, Commissioner Myers, this is your district, but just looking around at the compatibility along with what I see their ability to flex and the density bonus not being such a hard, fast rule, I'm inclined to support it. So thank you.
Commissioner Kemp.
Thank you. So the flex couldn't have happened before because there wasn't property around it. I mean, the first building that was built in 2017. It couldn't have flexed to anything else.
It couldn't have flexed anything else because it was the highest future land use category around this.
Yeah.
Yes, correct.
And yes, thanks for the explanations. I got them before. It's hard to understand, but I feel as though it is really circumventing the basis of, the land use in that area. While I'm totally supportive of the densities being up there and of the development, and in fact, look forward and encourage it. But I don't think this is the way to do it. To me, I mean, would it be, I was confused about why they didn't just go for changing the future land use comp plan category. Is that what, I mean, could you comment on that?
Yes, I sure can. The current designation of the property is OC20, and they certainly could have pursued a future land use map amendment. I can't say what staff would support or not support with an application that hasn't been submitted. But to the west, I mean, there's the ICMU 35 category, which accommodates the University Mall. That is the only area in the county that has that designation. And 35 dwelling units per acre is the highest we have as a designation for future land use categories. And then that allows bonuses to go up to 50 units per acre. And then they also have RMU, as Mr. Gormley was saying, the regional mixed use 35 directly to the east. So I think the applicant could make a compelling case for a map amendment for this property, if that's the question you're asking.
Right, and that would be, to me, the better way to do this, because I do look at this as really circumventing, and also I just wonder about precedent setting for any property at all in the future in terms of doing this. And I feel like it's a real runaround, a little bit of a slap in the face to anything we would set or expect in terms of good development practices. And I'll say this. I am really concerned, actually, in terms of the future. I'm not sure it will all be university housing. And I don't think it was necessarily intended at that initially. I do think that that's where they're going right now, but I don't think that there's going to be quite that much university housing needed. I think there's going to be other housing. I worry about the streetscape there. One of the density bonus, and using a percentage like 10% as a guide, is, if you think about it, I think these, I was told these buildings are like 6 stories high, I think, when we were talking about it. So if you look at the bottom floor, let's say being used for commercial, neighborhood commercial, whatever, then you might think 20%, but I guess typically they might do 10% or less, because they kind of do the frontage and then probably parking in the back to the streets and stuff. I think it's really important to have this stuff as frontage underneath commercial for the future. As the mall and the other things go away, I do think it creates and activates the streets and makes them safer and better, and it's the kind of community that we would want to aspire to. I was just at Armature Works yesterday, and I was looking, thinking about this, and I was looking at the first floor of the Pearl Building, and even though it has the huge Armature Works commercial, totally commercial site across the street, it's got that first realm activated for it, that's external for the street, for small businesses and the street. And in that, just right there, I was just kind of amazed to see there's a Michelin restaurant, one of the first in Tampa now. There's a TGH health clinic. There's a health food or health products type of store. There is an ice cream shop. And I just think having something, I think that this, it's asking for the density bonus. They're asking for the density bonus of what it was a standard of 10%, but I asked how much that would actually translate to, and it would be 1,800 square feet. It would translate, the density bonus would be, I guess we can wait a minute. The density bonus would be 1,800 or 18,000 square feet. And what they're doing now is 1,350 square feet. If it was 10%, 18,000 square feet, and what they're doing now is 1,350. So I think first they're asking for the density bonus, but the mix of uses at anywhere near 10% is not really a density bonus based on mix of uses. And then to do the flex over it, and then not to deal with the future land use and the future use of the area. I just, I can't support this. I don't know if maybe they want to go back to the drawing board on this, or if, I guess they could go back, go back and apply for, change of the comprehensive plan, because I think that's the more honest, straightforward, and better planning way to do this. And I'd hate to tell you the truth, to set any kind of precedent by doing this, and to circumvent and undermine our density bonuses by doing this, and just really making them meaningless.
Okay, thank you. Commissioner Wostel.
I was just going to say, and I see Ms. Corbett's in the back room. Hopefully she'll laugh a little bit at this. As the anti-apartment commissioner, it seems like we've really paved the way for apartments in areas that they frankly made absolutely no sense. But seems very difficult where it seems to make absolute sense, and maybe my brain just is too logical thinking to come to grips with that. But Commissioner Myers, I'm going to support whichever way you want to go on this, frankly.
I'm going to move for approval.
Okay, we got a motion to approve G3A and G3B by Commissioner Myers, second Commissioner Wostel. Commissioner Myers, do you make any other comments?
I'm elated when I see new projects coming into District 3. Thank you.
Okay, if we have no other board comments, please record your vote, G3A, G3B.
Motion carried 6-1. Commissioner Kemp voted no.
All right, with that, we're adjourned. Thank you.